Recording. All right. Tonight we're going to talk about Chapter 6, the defendant's answer. Last week we talked about the complaint or the petition. Hopefully that all went pretty well for you all. I haven't gotten a chance to look at those since they were just due today, but hopefully we worked with ProDoc or your own form or whatever and worked that out. Now we're going to be doing the opposite. That's playing the plaintiff's side. Now we're going to be playing the defendant's side. All right? So just remember that when you make a petition, of course, you're asking for something. You're asking for relief. You're asking for, that somebody did something wrong, and you're asking for them to basically pay the price. Well, in the defendant's answer, you're basically saying, one of a couple things. You're saying, I didn't do anything wrong, or I did something wrong, but it doesn't matter because I have a defense to that, or I did this wrong and that wrong, but not that, and or I did nothing wrong unless you prove I did. Okay, so it's kind of a combination of all those, or one or two of those, or something. Okay, and there's a couple differences. We're going to break them down a little bit, but in general, the big thing to remember, if you're in federal court, which, like I told you before, very few of you will practice in federal court, it's a paragraph by paragraph deal. You have to answer, admit or deny every paragraph in the petition or the complaint. In Texas and a lot of other states, you can do what we call a general denial. It means you can just say, I generally deny each and every allegation of the plaintiff and therefore require them to prove their case in whole or something like that. Respectfully, or pray for, wherefore pray that the plaintiff takes nothing in their cause of action, and that's it. Sign it, that's it. That would be an answer, literally, in Texas. Okay, and some other states. It's called a general denial. Just remember, federal, you have to go every paragraph and number it. Paragraph 1, defendant admits. Paragraph 2, defendant admits. Paragraph 3, defendant denies. Whatever. Like if you say, if paragraph 1 says the defendant resides in Harris County, Texas. Okay, you can admit that. Defendant was involved in an accident on June 6, 2013. I can admit that. Paragraph 3, defendant admits that he was negligent in the accident on June, whatever, it said 15th. Deny that. Okay? That would be what a federal answer would look like. Okay? All right, we're going to talk more in detail, but those are the two main differences from state to federal in Texas. If you live in California or New York or Oklahoma, wherever, you need to look up and see if you can do what they call general denial or paragraph by paragraph. All right. The function of the defendant's answer, we're going to talk about how an answer matches the allegations of the plaintiff's complaint, especially when you got to do it by paragraph by paragraph. Describe the minimum requirements of a valid answer and the process of raising affirmative defenses and 12b6 motions. We're going to talk about counterclaims, cross-claims, impleader, interpleader, class actions, and answer containing a counterclaim. Okay. Okay. Like I said just earlier, the answer is the defendant's response to the plaintiff's complaint or petition. Okay. Not only must the defendant respond in writing to the complaint, the defendant must answer each of the plaintiff's allegations in federal court. Like I told you, in the state of Texas and many other states, you can do a general denial. Just a general statement, you deny everything. Answers frequently contain denials, but they can contain admissions, like I said. You can admit whatever you want. Just be very careful what you admit to. Rule 7 creates the requirement for an answer. Rule 12 frames the practical issues involved drafting and filing the answer. Okay, this is the federal rules. All right, basically Rule 12 talks about the time frame, if there's a lack of jurisdiction, maybe failure to state a claim by the plaintiff, that kind of thing. Yes, Mario?
You said in Texas you can deny everything. What about, like you said prior to that, like in Chapter 1 it says you were there, so you admit to that. In Chapter 2 you admit to that. In Chapter 3 you don't. In Texas you just...
You mean paragraph?
Yeah, excuse me, yes.
Yeah, but see, that's the beauty of it. In the state of Texas, you can generally deny everything. Federal court, you don't want to do that. You don't want, if it's paragraph by paragraph, you don't want to deny your name as so-and-so. You don't want to deny that you were involved in the accident. I mean, if you truly were, okay? Because the judge is not going to be happy. He's going to say, wait a minute, your name's not Joe Smith? Well, yeah, it is. Why'd you deny that? But the state of Texas and other states allow a general denial. It's just a denial of everything. Now, in discovery, there will be things like, is your name so-and-so? Yes, I admit that. Okay. You know, they may send a request for admissions. You know, were you involved in the accident state? Yes, I admit that. Well, then you say, well, wait a minute, you denied everything in your answer. That's okay. In Texas, you can just do a general denial. Everybody understands, the court understands, the other attorneys understand. You're denying everything in general, but that doesn't mean like your name and all that kind of stuff. Federal court, they will basically sanction you if you start doing that stuff, but that's because you got to do every paragraph. All right? Good question, though. All right. Components of an answer, point-by-point response to each of the allegations raised in the complaint. Correct. Federal. Affirmative defenses and counterclaims against the plaintiff, that holds for federal or state. Okay. Affirmative defenses might be like court and satisfaction, statute of limitations, you know, that kind of stuff. Comparative negligence, in other words, you know, maybe I wasn't negligent because the plaintiff was negligent. Okay, something like that. Or statute of limitations. Yeah, I was maybe at fault, but it doesn't matter. Statute of limitations is run. Okay, those are affirmative defenses. Counterclaims would be, hey, it wasn't my fault. It was your fault. I'm suing you because you wrecked my car and you hurt me. It's very similar. A counterclaim in general is very similar to the complaint you just did, except for you basically cut and paste that and put it at the bottom after your answer. It's basically almost the same thing. Now, the difference real quick, we're going to talk about a little more, you do not have to have them served like a constable or a sheriff or anything like that. You can do it under the Texas rules 21A, but you can do it by fax, you can do it by email, you can do it by personal service if you want, okay? So you can do that on a counterclaim as long as it's part of your answer, okay? Because they've already appeared. They filed the petition. They filed the complaint, okay? So that you don't have to do. Even though it's like a lawsuit, it is, but they're already in the lawsuit. So you don't have to get them served like by a constable or something like that, okay? In other words, you don't have to get a citation issued for that. All right. You have a Rule 12b-6 motion. That's the same thing. That's like failure to state a claim. Something, lack of jurisdiction. It's something that's probably going to get the case dismissed. Okay? That's federal. A lot of times we just put it in as affirmative defense. But the 12b-6 motion could actually get rid of it before you hear the whole case. Okay? So it's something you could file. In other words, they don't have jurisdiction over me. I'm filing this motion. Boom, it's gone. We don't have to wait 6 months or a year to figure this out or 2 years to really get into this lawsuit. We can get rid of this tomorrow. All right. Function and minimum requirements. The functions allow the defendant to assert his or her defenses. Answer contained admissions, denials, and counterclaims, which we've talked about. Defendant's answer must conform to the minimum requirements set out in Rule 8, including short and plain terms. You know, admit to this. You can deny part of it. I admit in paragraph 3, I admit to that's my name, but I deny that I caused any damages to the defendant or to the plaintiff. Okay. Now, if you lack you might lack knowledge to admit or deny. In other words, if they say, the plaintiff, sues you for $20,000 they incurred in damages. Well, you don't know what they incurred. You haven't seen anything yet. So you say, at this point in time, can't admit or deny. Don't know if they incurred any damages whatsoever. You know the guy was hurt because he took by ambulance, but you don't know if his ambulance and medical bills were $20,000, $1 million, or $10. So you can't admit or deny it. Okay? Be very careful about those, though. Now, if you find out later that's not true, well, then you can deny it. Okay? But you don't want to admit something and then just come back and try to deny it. That's not going to look good. Okay? But if you don't have enough information at that time to admit or deny, that's fine. Later on, you can say, based on discovery and stuff, we now deny allegation number 6, whatever it is. All right. Like I said, that's federal. And you can do either one in your assignment to do an answer. I suggest you do a general denial. It's easier. It covers the same bases. Why not do it? You're not going to screw it up in the sense of, admit that, I should have denied that. Why? You just do a general denial. Now, in there you should look for affirmative defenses, such as comparative negligence, stuff like that. You should look in there, maybe you got a counterclaim against the other person thinking that they caused the accident. You're suing them for your damages. Those are some things that I'm going to be looking for in your answer. Okay? And that should be getting to be walked through with the program and stuff. All right. ProDoc should have all that information in there, so just input it. Also, make sure, and I know I told you this before, but make sure after you get ProDoc, it'll convert it over into like a Word document. Make sure that you have that document, you read through it. If there's blanks, go in and fill in. I think 1 or 2 of you sent me something saying, I'm not really sure to what to put in here, and responded to you. That's right. Don't just leave blanks, go, oh, that's what ProDoc did, so it's done. No. Go back and read it. Make sure it makes sense. Don't leave any blanks. Okay, you shouldn't have any blanks. And of course, in the answer, different than the petition, you should now have the court number and the cause number. Okay. All right, Melanie? Melanie, did you have a question? Jennifer, is it freezing up? Okay. Do you have a question? You want to type it real quick? Anybody else have a problem with the video or? Yeah. It's kind of because I still didn't understand what. Okay. Well, here's the deal. If you're not sure what to put in there, think about what you have to have. You don't have to use those words word for word. Okay? So, and I don't remember if I remember yours exactly, Melanie, but I think one was with injuries. Sorry, I don't remember the other one. It had to do with damages, I believe, but I just don't remember off the top of my head. But put in there, think about it. It probably has something to do with plaintiff or defendant caused injuries to the plaintiff. Okay, that's fine. You need the word cause. Approximate cause is better even, but that's it. You can say defendant caused personal injuries, defendant caused damages to the plaintiff, and the following other damages. That's fine. As long as you describe them what they are in general, that's fine. You don't have to use those exact words. Think about what the paragraph's asking. If you're not clear, what to put in those exact blank, reword it, as long as you've got the general idea. Like I said, you always want to use like causation or approximate cause. Those are important, but whether you call it personal injuries or damages, as long as you describe it somewhere, you're okay. Because there could be property damage. It may be a total property damage case. The car hit my house. It did damage to it approximately caused damage to my house. Okay. They approximately caused damage to my house and me because I was sitting in a chair inside and the wall fell on me. Fine. You know, think about what that paragraph is saying or what that sentence is trying to say, and you know, you can put it in your own words. Like I said, be careful, make sure it's halfway clear, but keep it general enough where you're not too specific where it ties you in. It is an art. There's no doubt there's a little bit of an art there to try to figure out that, you know, commonality between specific but not too specific, generic enough where we have some wiggle room in there. Oh, want to know about the vehicle, like the description of the vehicle? That's fine, you can say that. But realistically, all you got to do is say defendant's vehicle. You don't have to get specific enough to describe the vehicle in the thing. That would be more of a fact pleading rather than a notice pleading. You know, you have to say, it was the defendant's vehicle, which was orange and with, you know, black tires and cool-looking rims. What? Who cares? It was the defendant's vehicle. In discovery, you can get into, you know, were you involved in an accident? Were you driving your vehicle? You know, et cetera, et cetera. You don't need to get into that. Now, I will say this. If it's something other than just a standard vehicle, like if it's a truck, especially a semi-truck, you want to probably say the semi-vehicle or semi-truck hit me, because that, number one, right there, it's a bigger collision. You know, you wouldn't say, you know, the guy's tricycle hit me. That's not very damaging. It doesn't sound that, like, oomph. So, you know, but maybe it's an airplane. Airplane came out of the sky and landed and hit my house. Okay, that makes sense. You wouldn't say vehicle. How the hell's a vehicle fly and hit your house? Okay? Could. You know, people drive fast enough. I've seen them jump curbs and hit houses. So, you know, be generic enough but specific enough, I guess. All right. Drafting the answer. The prime purpose of the answer is to admit or deny allegations like we talked about. Admit, you agree, or stipulate to the allegations. If you agree and stipulate, that is something that the other side, the plaintiff, does not have to prove. If you admit your name is Joe Schmo, it's proven. If you admit that you were involved in the accident on June 6th, 2013, he doesn't have to prove that. Okay? He can read that into the record, and that's it. Or he can tell the court to take judicial notice of that. If you admit you were negligent, he can take notice of that. Then all he's got to do is go to proximate cause and damages. Now, if you admit that, yes, I approximately caused damages to the plaintiff, but it was under $500. It wasn't $1 million. Okay? So there's your argument. There is your case. Your case is what was the amount of damages caused. So you've limited it now, trial, to that issue, and that's fine. But you never do that without the consent of your client, number one, and of course this all goes through the attorney. You don't do any of this stuff and leave it at that until you talk to the attorney. He's got to sign off on it anyhow. It's a pleading. Okay, but sometimes I've had it happen. Yeah, I've done it too. We'll stipulate to negligence, but we're not going to stipulate to the damages because they're asking for $1 million, and it's only, we think it only costs $5,000 in damage. So you just try the case on damages. Am I sounding chipmunkish? Alvin, Theodore, which one? That's all I want to know. Wow. Is it better if I move up closer like this? Or doesn't it matter? If you want, okay, so it's not me. Must be y'all's connection. If you want to get out real quick and get back in, I don't know if you want to do that. you're probably not going to miss much in the first, next slide, but okay. All right. You deny, basically disagree with the contest allegations presented in the complaint, okay? So it's admit or deny, or you maybe can't do either, like I said before. If a defendant fails to properly deny an allegation, it is deemed to be admitted. Okay. Be very careful. Remember I said there's risks involved if you do a Texas one like this, each paragraph. Make sure you admit or deny the correct paragraph. You don't want to make a mistake and misnumber or anything like that. This is why, and the complaint or the petition is supposed to be numbered, the paragraphs, and the answer is supposed to be numbered. So make sure you're admitting or denying the correct paragraph, because it sure would make your client mad if you admitted something you weren't supposed to. And if you don't admit something, you skip something, then it is deemed admitted, which is probably not a good idea. All right? And this is what I just talked about. The effect of an admission is that the defendant is prevented from denying the facts during trial. Okay. Denying claims and other responses and answers. Before we go on, is everybody good where we're at? Everybody understands it? Everybody good? Okay. All right. The defendant's denial serves to form the issues that will be litigated in the case. Remember I said you can admit everything, this, and this, but we're going to deny damages. Okay, that's the only issue. It streamlines basically the case. The answer essentially creates the issues. The allegations denied by the defendant force the plaintiff to present testimony evidence on those allegations. Defendants are not limited to giving only admissions or denials. Defendant could admit part and deny the remainder. Okay, we talked about that. Just because it's all in one paragraph, you don't have to admit the whole thing. You can break it out. Make sure, this is where you need to make sure you're specifically addressing each issue. In other words, I admit this part of that paragraph, but I deny this part. Well, if there's a third part in there, you better answer, deny, or admit. Otherwise, that's going to be deemed admitted. So make sure you break out the parts that the allegations are. If you're uncertain, then deny it. Okay? Bad faith. This is in regards to the question before. If intentional misrepresentations or fraud activity, that can be the basis for additional award of damages. So don't deny something that you know is true. Okay? Like your name, something obvious. Whether you ran the red light or not, well, your client, of course, that I don't think you did. No, okay, you deny that. Make them prove it. But your name, come on. It's not going to look good to the judge if you deny your client's name. Now, truly, if he wasn't involved in the accident, then he wasn't involved. But if he was, he was. It's life. The defendant interposes defenses or other allegations out of bad faith, the judge is authorized to impose sanctions. That can be as severe as a couple things. Number one, it can wipe out the answer. As such, there's no pleadings, then everything would be deemed admitted. Not good. And or they could sanction financially or jail time. Okay? Now, jail time's got to be something pretty severe. But I've seen it happen. I've seen it happen. So they get crossways with the judge and saying, they're lying to the court. Man, judges throw contempt action on them. I've seen fined more than once. Thank goodness I never had either one, but it can happen. All right, failure to respond to the complaint. Under Rule 12a, the defendant has, this is incorrect. It's 21 days to answer from the date of service. 21. When this book was written, it was 20. Now federal is 21 days. Under the Texas rules, it's the first Monday after 20 days. Federal's 21, Texas is first Monday after 20. I'll explain that more in a minute. We'll do accounting. What is it in California, Oklahoma, New York, wherever? I don't know. It's probably somewhere around the time frame. Now, let's throw a little bit of a wrinkle in here. In federal, if you agree to waive the service by like a process server or sheriff or constable, you can take up to 60 days to answer. Texas does not have that same provision. Okay? But in general, it's 21. Now, in your quiz, or whatever you take online, put the 20 days, if it asks you, because that's set up for 20 days. But just know it's 21 days for federal, okay? Everybody got that? All right. Okay. Like I said, answer has to be in writing. It has to be filed. Just like anything else, if you file something with the court, you need to file it with the other party, or all the parties. You can do it by certified mail. In Texas, you can also do it by mail, email, if the courts are allowing email, which most, if not all of them are. You can do it by fax. You can do it by personal service. Okay. All right. Default judgment. If you do not file your answer within either 21 days federally and or the first Monday after 20 days, they can take a default judgment on your client. That means all the allegations in the complaint are considered true. If you screw this up, definitely malpractice. Always calendar a petition when it comes in, when it's due, so you can make sure it's answered in time. Even if you get a default, there's a good chance the judge is going to make you come in and prove up the damages, that being the plaintiff. But you don't want a default taken on you. I'm going to talk to you about two different things on default. Number one, we're going to get to calendar and showing you how to count the days in a minute. But number one, a default, if it's taken, is not always a good thing if you're on the plaintiff side. You may think, well, that's great. I got a default. We're going to run down to the courthouse and get our money. Okay, let me tell you what can happen there. This is something they don't teach you in law school. This is reality. A default, if there's insurance, say a basic car accident case, all right? If you sue that person, and you know that person's got insurance, and you go down and take a default, and you find out that the defendant, who you served properly, never gave it to his insurance carrier, and he never filed an answer, there's a very good chance, I would say 99.9% chance, if it was never given to his carrier or his insurance agent, that insurance will not have to pay that claim. Because in everybody's policy, homeowners and automobile, there's a provision in there that the insured has to cooperate with any type of claim with the insurance company. Well, if they don't send you the document, in other words, if the insured does not send the insurance company the petition to answer it, that's not cooperating, and they can basically negate the policy. So, hint for you, personally, if you ever get sued, make sure you get it to your insurance company. make sure you fax it to them, email it to them, or something where you have a record of it. Because then if a default's taken, then that's their problem. They're going to end up paying it, not you. So, let's back up. If you take a default and you think, oh, look, we're going to get all this money, and the insurance company was never notified, yeah, you may get a default judgment on somebody for $100,000, but they don't have any money. The insurance company does, but he never gave it to the insurance company. This is where you might reconsider taking that default. Lots of times what the insurance companies will do, they'll say, hey, here's the deal. Here's $500, $1,000 for your time. Reverse, let's take the default away, and we'll defend the case. And that's what they'll usually do. I've done it on both sides. As a plaintiff attorney, I've taken the default away, let the insurance company come back in, give them time to answer, and they're in the case. Yeah, I've got to prove my case now, but I'm also going to collect money if I win. And I've been on the insurance side where I've approached plaintiff's attorneys saying, here's what we'll do. We'll give you $1,000 for going down and hassle, but we'll reinstate the insurance policy on the case, and we'll move forward. Okay? All right, everybody understand that? Why would you do what? If you're the insurance company, okay. The main reason is because until that's determined, okay, as a matter of law, which is going to cost them a ton of money, and it could open a case for bad faith. Because maybe the insured told them about the case, but didn't actually send them the petition. Okay, so were they on notice? Maybe. So there's a lot of questionable things. Okay? Insurance companies normally will do it. I'm not saying all the time, but normally they'll do it. Because they don't like bad faith cases. Why? Because they get in front of a jury. If a jury hears that an insurance company is trying to get out of a case, even though they got the premium for it, now they want to stick their insured, people don't like insurance companies very much. That's why they do. That's why they kind of come back in. Yes, sometimes it's a okay. State of Texas, even if they send the complaint or the petition right to the insurance company, that is not proper service on the defendant. You have to personally serve the defendant. Now, can you send a courtesy copy to the insurance company? Yes. Would that put them on notice? Probably. Okay. All right. Good questions, though. All right, let's count the dates out real quick. I'm just going to pull up October on the bottom corner of my screen, the calendar. All right, say for instance you get sued, your client gets sued, and they're served on October 1st. Okay? Under federal law, it's 21 days, remember? So, you never count the day you're served, your client served. So the first date would be the 2nd. So the 2nd is the number 1. 3rd is the 2nd day. 4th is number 3. Okay, we got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. 21. Okay, federal's 21. So your answer is due by the 22nd. Okay, everybody got that? Right? In federal. All right, let's do state of Texas. You get served on the 1st. Your client gets served on the 1st. Now, for just this deal, like the 22nd is the due date, try to get your answer in for sure by like the 17th. Don't wait until the 21st or the 22nd. Try to get in like, 4, 5, 6, 7, 8 days before, if possible. All right. Because if something happens, I don't know, your car breaks down that day, something you can't get into work, you're sick for a couple days, you still got some time to get it done. All right. Served on the 1st, let's do Texas, which is the first Monday, okay? First Monday after 20 days. Second is the first day. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 20. All right, the 20th day is the 21st of October, right? Okay. Now, it's the first Monday after 20 days. So your answer is not due until when? That's right, Sandra, the 27th. There you go. Okay? Everybody understand that? And normally it's due, hopefully I don't mess this up. I think it's either 9 or, I think it's 10 o'clock a.m. on that date. I believe it's 10 o'clock. I've looked at it, but I don't worry about that too much because I try to get it way done before that day. But it's 10 o'clock. Okay? So don't wait till the last day, please. If it falls on a Saturday or Sunday, it's due that Monday. So if the 20th day, well, that would never happen, of course, with Texas or weekend. Now, if Monday is a holiday, maybe it's Labor Day, okay? Courts are closed. You get to the Tuesday then. All right? There again, don't wait that long, please. All right. Everybody good? Okay. You would be shocked at how many people do not know how to count those dates off correctly. And I mean law school students included. Okay? All right. The defendant must respond to each allegation raised in the complaint. We talked about that. If a defendant fails to do so, the facts, known as the averments, are deemed to be admitted. Talked about that. This is why general denial by the state of Texas is a beautiful thing. Affirmative defenses is an excuse by the opposing party that not only negates the allegation but also puts forth a legitimate reason to avoid enforcement. Statute of limitations is a very good affirmative defense. For example, in other words, yeah, this may or may not have happened the way the plaintiff said. Doesn't matter. He filed it 2 years and 3 months after it happened. It's 2-year statute of limitation. Case is gone. Chances are it is. Okay? That's the way it works. What you do is you put that in the answer, and then you file your motion for summary judgment if both sides agree that it happened 2 years and 3 months ago. Judge should grant it, case should be dismissed, move on to the next one. You hope your cases when you're on the defense side is that easy. Not normally. Okay. Defendant raises affirmative defenses in the latter portion of his or her answer. In other words, do your answer. If it's general denial, then do your affirmative defense, then probably your counterclaim. Okay. Affirmative defenses provide the defendant the mechanisms to have the case dismissed. Here again, if you do not ask for it, you will not get it. So don't think, well, I'll just leave that off till later and you don't claim an affirmative defense and then you get up to trial. Judge, his case wasn't filed in time. Judges say, you never pled it, you didn't plead it, you ain't getting it. So make sure you plead it. Put it in your answer. Under Rule 13, a counterclaim is a claim made by the defendant against the plaintiff, a countersuit brought by the defendant against the plaintiff. Okay. Remember, counterclaim is across the V. Plaintiff versus defendant, defendant versus the plaintiff. cross claim would be plaintiff versus defendant. Defendant 1 sues defendant 2. That would be a cross claim. It does not cross back across the V versus. Okay? Everybody understand that? Counterclaim, cross claim. Yes? No? Maybe? Admit, deny? Okay, good.
So just to clarify, it
Yes,
would
sir.
be petitioner or plaintiff versus defendant, and then in your counter you would just put counterclaim defendant against the plaintiff without the verse?
Yes, correct. You would not change the style of the case. In your counterclaim down below, you could say counter plaintiff, ABC Inc., which is also the defendant. Okay, so you could say defendant, comma, counter plaintiff, ABC Inc. is suing plaintiff, counter defendant, John Schmo, for blah 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 blah. You know, whatever you're going to say. You can call them counter plaintiff, counter defendant. You could call them plaintiff or defendant. Okay. It does get tricky when you start using this language back and forth. After you see this kind of stuff, it's easier, you know, because you just got to think about what it is. Because if you have a claim, and I know we talked about this a little earlier, A versus B, and then B later brings in C, that would be a third-party action. Because they brought in a party that wasn't in the original case. So that means B would be the third-party plaintiff, still the defendant though, you could call him defendant, third-party plaintiff, versus the third-party defendant, you know, Jackie Smith. Okay? All right. But I do not suggest you do a third-party petition in an answer. You can do a counterclaim, but a third-party petition should be a separate document to bring somebody into the case. Keeps it cleaner. Okay? Counterclaim resembles the original complaint except as brought by the defendant against the plaintiff. Okay, we know that. All right. Everybody good so far? You know, it gets a little confusing. All right. Compulsory and permissive. Now, two types of counterclaims. A versus B. Okay, B is going to sue A. Counterclaim across the V. Compulsory counterclaim is a counterclaim that is required to be pled because it basically comes out of the same set of facts or the same transaction. So in other words, if A is suing B because of a car accident, and B is like, wait a minute, it wasn't my fault, it was his fault. He caused damage to me in my vehicle. You need to sue him back. That's a compulsory. A permissive counterclaim is not required to be filed. It can be filed somewhere else, another separate case, because the facts don't arise from it. I'll give you an example. A sues B because A says B hit their car. Okay, negligently hit A's car. B said, oh, you're suing me for that? Well, 2 weeks ago, you know, we entered into a contract and basically you didn't pay up. So I'm going to sue you for that breach of contract. That's a permissive counterclaim. It does not have to come out of the same set of facts. I could also bring that as a separate lawsuit if I want. But you can say, I wasn't going to sue you, but you're suing me for that, so damn it, I'm going to sue you for this. Okay, it's your priority. Okay? All right. Kind of makes it a little weird for the jury, but sometimes the best defense is a good offense. Okay? All right, res judicata. No, this is not something on the Lion King. Okay. Res judicata. This is the principle that a legal finding on an issue in one case may be dispositive of that issue in another case. Basically, it's there to basically stop lawsuits from going over and over again. In other words, if I sue A and B, this happened to me. Basically, I sue A and I get a jury finding, or finding, whatever, that A was negligent. Well, let's back that up. Let's strike that. AB is suing C. A and B suing C. A and B are two people in a car saying B hit them. A sues C and gets a finding of negligence and damages of $100,000. Well, now B sues C. Basically, B says, we don't have to prove negligence. We already proved they hit our car that we were involved in. Same car, same set of facts, same everything. Okay? Lots of times the judge will say that's res judicata. In other words, it's already been tried. We don't need to try that same issue again. Now, what the damages are going to be different because they're not the same as A, but it's the same car, same everything. All right, a different rule applies to permissive counterclaims. The judge might decide basically to separate out permissive counterclaims to prevent confusion. Okay. All right. Replies to counterclaims. Pleading used to respond to the allegation to counterclaim. You can call it an answer. Well, we call it an answer to a counterclaim in state court. Federal court, they call it a reply. Either one will probably work. Okay? State court, I would definitely use the word answer. You're going to answer it just the same way. You can do in Texas, state courts, you could do a general denial. Say, hey, plaintiff, counter defendant, serves a general denial and denies each and every allegation by counter plaintiff / defendant. Or you can admit or deny each paragraph. Federal, of course, that's what you'd have to do. All right, everybody got that? Understands that? Yes? Maybe? No? Okay. Just making sure everybody's awake. Everybody's like, you know, we're almost done. Football's over. We'll get done early tonight, but we're almost there. Hold on. All right. I want to make sure you understand this if you have any questions, though. Okay. Cross-claims. Let's talk about cross-claims. Cross-claims, remember, I mentioned this a little bit earlier, would be like A versus B and C, and then B goes, yeah, it was C's fault. So I'm going to cross-claim against against C. So A versus B and C, so there's two defendants, B and C. And B decides to sue C. Or C decides to sue B also. It's a cross-claim. Okay. Lawsuit against a party of the same side. Plaintiffs or defendants suing each other. A cross-claim must arise out of the same transaction or facts. So in other words, it's not permissive, not like a counterclaim, which can be permissive or compulsory. It has to be a compulsory cross-claim. In other words, it's got to arise out of the same set of facts. A party may bring a cross-claim against another party to allege that one party is culpable in the action of the other. Well, of course, that would be the reason. And you must respond by an answer. Okay. Now, I haven't said this yet, but I'm going to say it right now. In general, it's kind of tricky, an answer, okay, is always an appearance. An answer is always an appearance. In other words, in front of the court. But an appearance is not always an answer. So, in other words, somebody files a lawsuit against your client, and you send something to the court saying, "Hey, you know, I don't like this thing. I don't know what's going on, but I don't like it." Well, that's probably an appearance. That's probably not an answer. That means you've appeared in front of this court, but you do not have an answer on file, and a default can still happen. Okay? An answer is always an appearance, but an appearance is not always an answer. So make sure you deny the allegations to make it an answer. Now, in saying that, if somebody files a lawsuit against your client, and we talked a little bit about this last week, and you don't think they have jurisdictional, in personam jurisdiction or subject matter jurisdiction, whatever it may be, or there wasn't proper service, whatever, you need to file a special appearance. In other words, we are specially appearing, the defendant, because we do not believe they have proper service, or there's no jurisdiction on my client, whatever, blah, 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 and you put it all in there, why, and all that. And then you file your answer subject to that. Remember what I said? Make sure you file a special appearance first. Because if you file the answer first, now you've basically given up any claims to jurisdiction. You've acquiesced to the jurisdiction. Okay? So make sure you file your special appearance first. If you're doing it by email, I would suggest doing the special appearance of why there's no jurisdiction or whatever you're claiming. Then I would get out of the system, and I would then get back in the system with the courts and file your answer. Make sure your special appearance got filed, get out, then wait a few minutes, file your answer. Or if you can, file it the next day. That way it's going to be clear that your special appearance is filed first. Okay. Everybody good?
So
yes,
just
sir.
because you file a special appearance, you still got to comply then with the 20-day or however 21-day deadline, depending on the court.
Unless you are super, super certain that your special appearance is going to be granted. Because if it's denied, guess what? You better have an answer on file quick. Now, technically, the court can't file or can't grant a default judgment. I've had this happen. Court can't grant a default judgment if there's an answer on file. I've literally picked up a file from another firm one time. They never had an answer for the counterclaim. And basically, as soon as I found out we were in court and they were asking for a default, I immediately wrote something down on a piece of paper, handed it to the court. The court says, well, here's his answer, so I can't grant it. It's like, hey, you know, you can do it that quick. But I would suggest, yes, filing your special appearance and then filing an answer behind it. Okay? Like I said, you could have one ready right there. If the judge denies a special appearance, then you say, Judge, then I'd like to file this answer. You could probably get away with that. Except for now, all the courts are saying, well, you got to do it by email. So, okay. Does that answer your question? Okay, good. Good question, though. All right. Cross claims cannot be brought against party on the other side of the action. Well, no, that'd be a counterclaim. Rule 13 does not impose a time limit for bringing a cross claim. Normally not. Now, there are certain time limits for these. Some are set out in what we call a docket control order that the judge will send out. When you need to bring in third parties, by what time do you need to have your cross claims, what time do you have to have your counterclaims, all that kind of stuff. Usually for cross claims, it's not a problem. Usually for counterclaims, it's not too big of a problem either. Why? Because the parties are already in it. Usually where the problem comes in is bringing into a third party. The judge doesn't want a year to go by, and all of a sudden you go, I need to bring somebody in. They're like, wait a minute, we've been going through this litigation and discovery for a year. Now you want to bring somebody to the party? Why didn't you do this 6 months ago, 8 months ago, a year ago, whatever? But if all three parties or whatever are involved, and then all of a sudden you're cross-claiming back and forth, well, they've been involved. You know, it's not as big of a deal to the court. Bringing a third party in is. But just check, always check the rules, and always check the docket sheet, the docket control order, and usually it'll be, of course, in the rules or outside or in the docket control order. Okay. The federal rules, I can tell you, are a little more stringent on that. Okay. Because sometimes, even if you've missed the deadline, you can always request leave by the court. And normally, if it's not going to set the case off by much or at all, the court will grant it. You say, Judge, we just found out about this third party. You know, we need 3 more months than we thought, but we need to bring him in. This is why we just found out. Okay, most courts are pretty good about it. You know, where they're not good about it is, well, how long have you known about this? Oh, about 2 years. Well, why didn't you bring him in 2 years ago? Yeah, we didn't know. We didn't decide to. Well, too late then. Okay? So just watch that. Third-party claims. This is what I was kind of talking about. Okay? This is where A is suing B, and all of a sudden B may be suing C. Okay? Sometimes. This is where the third parties come in. Well, an impleader, we'll go through these one at a time, but impleader is basically where third party, in other words, you want to sue them. Okay? You want to bring in the third party. Like I said, usually the deadline federally is within 10 days of the defendant's answer on this, to bring in a third party. Otherwise, you have to ask for leave of court. But always look at the docket control order from the judge, if there is one at that time. Okay, interpleader is where you put money or something in the registry of the court. For instance, there's a lawsuit for a car accident. I'll give you the scenario. You got A and B suing C. C caused the accident, okay? A and B are the plaintiffs. And all of a sudden, they're both hurt bad, very bad. Well, B has a $20,000 policy. That's it. They know the damages are probably $100,000 each, if not more. Plaintiff's like, that's all I got. So what the insurance company will do is they'll just say, hey, we want to interplead the $20,000 so we can get out of this. Here's our 20 grand. Now, they probably still have a duty to defend, but chances are if they look at this guy and they say there's no more money to get out of this guy, he doesn't have anything, no reason to go forward. So they can interplead that $20,000 into the court. Basically, let A and B fight over it. Or maybe A and B is suing C for the title of property. And C's like, hey, let me tell you, I don't know whose property this is. It's not mine. I sold it. But these two are claiming it's theirs, and that's fine. You know, here's the property. I interplead that in the court. and let them fight over it. Okay? All right. Intervention is basically a party who seeks to get involved in the lawsuit. They want to intervene. Okay? Basically, the party seeking to intervene must show that a U.S. statute, well, in Texas, it's Texas law, gives the party an unconditional right to intervene, or that the party claims interest in the litigation and resolution of the case without the party's presence may affect his or her property rights. Here's where this comes up most often that I've seen. A medical provider, okay, is owed, we'll say, $20,000 by the plaintiff for treating them for, we'll say, the car accident. And he's not getting paid. Well, he wants to make sure that if that plaintiff gets money from the defendant for his injuries, that he gets his 20 grand. So he intervenes in the lawsuit. Workers' comp will do this a lot. Okay? Or insurance companies with subrogation rights will do this. In other words, workers' comp's paid out the worker that was hurt on the job because some other third party caused it. You say, man, we paid this guy benefits and medical bills of $100,000. If the plaintiff gets their money for their damages, we get our $100,000. And matter of fact, workers' comp gets their money first. So if he gets $110,000, well, the attorneys usually can argue that they get their share for taking the lawsuit, which they normally get up to like a third. Then after that, the workers' comp would get the rest, pretty much. That's state law. Okay, so that's where you see an intervention. Okay. Everybody good on those three? I've seen all three. Third-party cause of actions, suing a third party, that comes in a lot in construction cases, where somebody builds a house and it's bad, and the plaintiff sues the contractor, and the contractor sues all the subcontractors, brings them all in third parties. He sues the framer, he sues the slab guy or the foundation guy, they sue the electrician, they sue the air conditioning people, they sue the window people, whatever, they sue everybody. Okay. Intervention, like I said, you see that in insurance companies, where insurance companies have an interest, or a doctor or a healthcare provider has an interest and they want to get involved and get their money. Because once the plaintiff gets the money and spends it, maybe he doesn't have anything else. Good luck in trying to get blood out of a rock again. All right, class actions real quick. Very, very few of you will ever work on a class action. It's a very specialized field nowadays. It's so expensive. Basically, it's a lawsuit involving a large group of plaintiffs who bring a suit against the defendant. Under Rule 23, a group must establish 4 things. Number of plaintiffs is so large that the following traditional would be impractical. In other words, it would be such a burden on the courts, it would be crazy. There are questions of law or fact common to all. The breast implant litigation, the tobacco cases are another one. Fen-Phen was another one. Asbestosis or asbestos was another one. Those were all big class action cases. The representative plaintiffs have claims and defenses that are similar to the entire class. 1 or 2 different people may be damaged differently, more severe than the others, but their claims are all the same. Smoking hurt them, breast implants, leaked and caused damage to their body, whatever. Okay. The representative plaintiffs will be fair and adequately provided their interest of the entire group. Okay. All right. If you work at a firm doing that, trust me, they're going to know 10 times more than I know on it, and it is more complicated than that, but it's very, very specialized. But that's just a general rule. You don't see many class actions in state court at all, basically. They usually don't have it that way. It's not usually set up that way. Federal, you will, like I said, and I gave you some examples. All right, summary. The BP explosion is a good example. Yeah, Marie says, wow, I'm starting to lose my voice. Glad we're about done. All right, summary. The response to a complaint is usually known as the answer. The answer contains the defendant's response to each of the allegations raised by the plaintiff in the complaint. Federally, yes. In the petition, general denial is fine. You can do it each and every, but be careful. The defendant's answer must also set out specific defenses. We talked about a few of those. And I think it's under, let me see if I can come up with a rule. I think it has a rule on it. Let me see if I have that written down. Ooh, affirmative defenses. Where was that rule down? Did I give you that rule last week? I thought I did. Did I give you the affirmative defense rule? Anybody remember? How's y'all's memory? Everybody's like, oh, I slept last week. I don't remember. Let's see if I got it. Otherwise, I can look it up real quick. I want to help you out on your thing here. Hold on. Let me look it up. This is why when attorneys say, oh, I know everything, I know every rule, yeah, right. Sometimes we have to look things up. Key is knowing where to look it up, so hopefully I'll make myself a liar and I find it for you here. Should be able to. Yes. Texas Rules of Civil Procedure 94. Okay. Texas Rules of Civil Procedure. And of course, since you're going to be doing a Texas answer, you might want to look at that rule. It will tell you different defenses. And ProDoc will also help you out in there. But some are court and satisfaction. That comes into play like if you've paid off a loan or something and they say you haven't. Arbitration and award, in other words, you've already been awarded something. Assumption of the risk, which in Texas is contributory negligence or comparative negligence. You sign the contract maybe under duress. No consideration, fraud, illegality. In other words, it's illegal to have this. In other words, Judge, I paid him $5 million for, 20 pounds of heroin. The judge is going to say, yeah. But he didn't give me the heroin. Well, guess what? I ain't going to let you do that because it's an illegal act. So that ain't going to happen. Okay? That's an affirmative defense. And number one, you're probably going to jail because now you're a drug dealer. So not the smartest plaintiff in that case. All right. Okay. Res judicata, we talked about the statute of limitations also. Some pages have 3 different page numbers on them. I don't get it. What are you talking about? Am I missing something? I see something. In our book? Yeah. Oh, you're talking about for the listing of affirmative defenses, you mean? Is that what you're talking about? I missed the first thing. Okay. Oh. Well, can't help you there. I didn't publish the book. Okay? So, like I said, I find mistakes in there, and that's why when I find them, I point them out. Okay? That's the best I can tell you. This book is picked by the school, and in general, it's a pretty good book. I will say this: it's pretty easy reading, but there are a few mistakes. And like I said, when I run into them, usually I'll tell you, like the 21 days thing. Okay, it does do a good book about simplifying it, because I've had other civil procedures book that it's like, what the heck are they saying? I know kind of what they're saying because I've done this for 20 plus years, but if I was a student, I wouldn't, it'd take me forever to figure it out. Okay. Okay. Any questions, concerns, problems? Like I said, do your best, use ProDoc. Everybody okay on ProDoc? You probably struggled a little bit, but it'll be easier the more you use it. I'm not a guru on it, but it's, when I do use it, it's not too bad. Okay. Yes, Jennifer.
Hi, one quick question. When I was using ProDoc, and it was my first time really trying to put something together on it, so I'm not even sure if it was right at all, but it said one thing where it was asking for like how much you were, you know, like for the damages, how much you were wanting for damages.
Right.
And I know you said, I know you said not to, you know, you said not to put anything specific. But with ProDoc,
right.
it kept like, it only, you had to choose something, whether it was less than 100,000 or
right.
between 100,000 and 200,000. Right. You had to choose something.
Right. And for that instance, you need to choose just because, well, for that instance, you need to, it's okay to put whatever number, discovery level. Anything below 100,000 is discovery level 1, remember? So you need to go into discovery level 2. So you probably want to put over 100,000. Now just think about it. If you put over 100,000, what do you care? I mean, you know, and just remember that you can always go in, after it puts into the Word document, you can change it to whatever you want. You can put in an amount, you know, to the jurisdiction of the court. But be very careful because nowadays they have discovery limits, okay? We talked about that. Not that much because we haven't gotten discovery, but there's discovery limits. Hold on. Let me show you because we're kind of getting ahead of ourselves. But
yeah, because it did ask about discovery, which discovery level.
Right, right. And that, let me see if I can get it more specific for you. Okay. All right. This is why they're asking for that. All right. Let's see, this is changed to 100,000. Okay. Let's see if I can find it here. Level 1 case. Okay, level 1 is damages to $50,000. Okay. For some reason, I want to say that changed to 100,000. But level 2 is, you know what? Do I have a supplement with this? Yeah, I got the new version at work. See, we don't deal in this anymore because we don't go after lawyers for based on money. We go after them for like sanctions. But something tells me it changed to level 2 or 100,000. I can look it up for next class. When we get to discovery, I'll have something. Level 2 is, well, of course, anything over that. And then level 3, let's see if I can find level 3 real quick. It's going to be, and of course you get different things like 6 hours and 25 interrogatories and all that, but I'm just looking for the pleading side of it. Okay, I don't know why I can't find level 3. Under most lawsuits, of course, yeah, under level 2 and level 3. There it is. Sorry. It's basically complex cases, not easily fit into the framework. Basically, these are where you got to ask the court by motion for level 3, and basically you set your own deadlines and all that kind of stuff. Okay, so that's why I believe. You know what? Let me see. Hold on. Let me see if I can find something real quick to see if that's changed to 100,000. Something tells me it has. Yes.
I guess I was just wondering because for the assignment, The only thing that it really told us definitively was that there was $10,000 in damages, or there was an excess of $10,000 of damages to the car.
Right.
So it wasn't, besides that, then it was saying the medical bill and damages and everything, so I wasn't really sure which one to go with.
Yeah, and the reason we use that example is that number one takes it out of JP court and gives you, remember, jurisdiction, okay, subject matter jurisdiction in district court because you're like $10,000 or more, so you have the jurisdiction there. Then really what it goes to is, okay, are you level 1 or level 2 discovery? You know you can be in district court with 10,000 or more than 10,000. So then do you do level 1 or level 2? Level 1 is anything under 100,000. So if you would say, we're going to do this as a level 1, that's fine. Then you'd plead less than $100,000. If you want to do it, unfortunately we haven't learned about discovery yet. Maybe you have in other classes. Level 2 would be anything over $100,000. Okay, so I don't care either way. And just remember, when you put it in ProDoc, remember that puts it out into, then converts it to a Word document. So if you do want to be specific and say in the amount of at least $20,000, okay, then you could go level 1 or level 2. Now the court may say, hey, you need to clarify that under the discovery rules to say if it's over 100 or under 100,000. But if nobody says anything and you say it's level 2, it's level 2. You see what I'm saying? But you might want to distinguish it. But here's the big thing. If you think, this is where you don't want to get hooked in too much. If you think, wow, this person's hurt and they're getting continued treatment, they already got $10,000 in medical, wow, they may get more medical. Well, you don't want to limit yourself to 100,000, say less than. So you automatically would just say, you know, it's going to be over 100,000 because you just don't know right then. Your guess is that it may be right around 100,000. Well, you don't limit yourself. Okay.
Okay. When it went into Word, then I just kind of reworded it to not limit myself.
There you go. That's fine.
Because it seems like the person was going to need future medical care.
Right. Because listen, somebody may have $10,000 worth of damages right now, but you've got a doctor that's saying, man, this guy's going to have surgery in the next 3-4 years. Okay, so you wouldn't limit yourself under 100,000 because I can tell you back surgery or something like that is going to cost $50,000, $60,000. Well, now you're up to $70,000 just in medical, not including lost wages, not including pain and suffering and all that. You're going to easily blow that 100,000. So that's why I said the new mark is at 100,000 or less, or 100,000 or more, because of the new discovery and the way it's set up. Like I said, it used to be 50, and they just changed it last year. That's why this book, which is a 2013 book, is already outdated on that. Crazy. Okay, it's only a year old. So that's why ProDoc's kicking out the 100,000, and that's why you can easily say, if you can, if it's a $5,000 claim, just say it's less than 100,000. And of course, remember this: if it's a $5,000 or $10,000 or $20,000 claim, and you're suing Walmart, now you want to change that. It's less than 75,000 because you don't want Walmart coming in and removing it to federal court. If it's over 75, well, it's over 75. But you want to make sure that statement says under 75 if you want to keep it in state court. Okay? So just because ProDoc won't allow you to put something in there, that doesn't mean you can't move it over to Word, of course, and then go back and revise it. But just remember, that's what I'm saying. Remember when you revise it, what you're affecting. You might be affecting your discovery, because you can't say, well, this is a level 2 discovery case, and we're claiming less than 100,000. The court's going to say, no, that ain't going to fly. If you're claiming less than 100,000, you need to be a discovery 1 case. Okay? There again, if you say, well, it's less than 100,000, and they remove it to federal court, good luck in telling the federal judge, oh, judge, I meant to put less than 75. Well, you need to put it. He may let you amend it. He may then keep it down there. But be careful of that. Okay? So that's why whenever you see something in ProDoc like that, that forces you to pick something, chances are there's a rule out there affecting that. And that's why then go look up in the book and say, why is this affecting this? You know? And then look at the discovery and all that kind of stuff. Basically what I've kind of told you should now hopefully put you and understand that better. And I honestly, I didn't remember ProDoc did that. Okay? So that's where, unfortunately, we can't teach, you know, everything before a complaint. We have to take it in order: complaint, answer, discovery, that kind of stuff. Not only does that follow 99% of the books out there, it's procedurally the way to go. Okay. Everybody understand that? Okay. Good question, though, because these are things that come up. That's why I said when you see something come up like that, that should raise the question, you know, what's going on there? How come this is limiting me? How come it's forcing me to put a number in there? Well, it's forcing you to do that because they want you to pick a discovery level, and they want it to match. Okay? But always don't ever forget, if you're suing a company or somebody out of state, if you want to keep it in state court, then you better plead less than $75,000. Okay? So just remember that. Okay. Good? All right. See, those are the type of questions that I want you guys to ask, because it really does bring something to the forefront that I can teach you all that's not necessarily in the book, but it's reality, and it's something that maybe some of you, more than one of you, have questions. Okay. I mean, I try to, you know, figure out, you know, what you need and what you don't need, but sometimes there's issues out there that, you know, that you see and they're like, what does that mean? And it brings up a good point that we can discuss and talk about, and why they're basically doing something or why something is written a certain way. And like I said, if I don't know the answer, I'll find it out, but usually I can tell you the answer pretty quickly. Okay. All right. That'll do it for tonight then. All right, do your answers. Like I said, look for affirmative defenses in there. Look for counterclaims. You know, that kind of stuff. No questions? No more questions? Okay. All right. Well, we'll see you all next Monday.